I understand that informants are important to the prosecution's case, as well as they preserve the public's interest. I understand the need for them to keep their identity secret. And on the other hand, disclosing an informant's identity is necessary when the accused will suffer a great injustice. So, how do you convince a judge to order the prosecutor or prosecution to disclose the identity of an informant? And that's what we're going to talk about today. And we're going to review a case and hear from some Supreme Court justices discuss prerequisites in determining whether to order the prosecution to disclose the identity of the informant or not. So let's get started. In 1955, in the Northern District of Illinois, petitioner Albert Roviaro was indicted on 2 counts by a federal grand jury. The first count charged that he sold heroin to John Doe. The second count charged that he did then and there fraudulently and knowingly receive, conceal, buy, and facilitate the transportation and concealment after importation of heroin, violating 2 federal statutes. Before trial, Roviaro moved for a bill of particulars, requesting, among other things, the name, address, and occupation of John Doe. The government objected on the ground that John Doe was an informer and that his identity was privileged. The court denied Roviaro's motion. After the denial of Roviaro's motion, he waived a jury trial and was tried by the district court. During the trial, government witnesses described John Doe's part in the charged transaction. And the witness described Doe's participation as follows. The government witness, Bryson, a Chicago police officer, testified that he hid himself in the trunk of John Doe's Cadillac. And he heard the men, Roviaro and Doe, engage in a drug transaction, while Agent Durham, a Federal Bureau narcotic agent, followed the Cadillac. And while in the trunk, Officer Bryson heard Roviaro greet Doe and direct him where to drive. At some point, at Roviaro's instructions, Doe stopped, cut the motor, and turned off the lights so as to lose a tail. He then told him to continue further down. Roviaro asked about money Doe owed him. He advised Doe that he had brought him 3 pieces this time. When Bryson heard Doe being ordered to stop the car, he raised the lid of the trunk slightly. After the car stopped, he saw Roviaro walk to a tree, pick up a package, and return toward the car. Officer Bryson heard Roviaro say, "Here it is, and I'll call you in a couple of days." Shortly thereafter, Bryson heard Agent Durham's signal to come out, and he emerged from the trunk to find Durham holding a small package found to contain 3 glassine envelopes containing a white powder. So back to the court hearing. Next, counsel for Roviaro, in cross-examining the government witnesses, sought repeatedly to learn John Doe's identity. The court declined to permit this cross-examination, and John Doe was not produced, identified, or otherwise made available. Roviaro was found guilty on both counts and was sentenced to 2 years imprisonment, the sentences to run concurrently. The Court of Appeal sustained the conviction, holding that the concurrent sentence was supported by the conviction on count 2, and that the trial court had not abused its discretion in denying Roviaro's requests for disclosure of Doe's identity. The United States Supreme Court reversed and remanded, holding in the circumstances of this case, failure of the court to require disclosure of the identity of the informer was reversible error. So let's look at some prerequisites that the court looks to in making a decision to order the prosecutor to disclose the identity of the informer. Where disclosure of an informer's identity or of the contents of his communication is relevant and helpful to the defense of an accused or is essential to a fair trial, the government's privilege to withhold disclosure of the informer's identity must give way. So, relevance and essential to fair trial are the key terms. Because remember, touchstone of due process is fairness. Keep that in mind, fairness. The court continued, no fixed rule is justifiable. The public interest in protecting the flow of information to the government must be balanced against the individual's right to prepare his defense. Where the non disclosure is erroneous depends on the particular circumstances of each case. The particular circumstances of each case, that's important. Taking into consideration the crime charged, the possible defenses, the possible significance of the informer's testimony, and other relevant factors. The key phrases are public interest versus the accused right to defend self. For example, the provision of the statute authorizing a conviction when the government has proved that the accused possessed narcotics unless he explains or justifies such possession emphasizes petitioner's vital need for access to any material witness. Significance and essentiality are the key terms here. These are just some prerequisites. Of course, there are others. Let's look at the Supreme Court observations leading to its conclusion in this case. One, the Supreme Court noted that the informer was not expressly mentioned in the relevant charge of the indictment, but the charge, viewed in connection with the evidence introduced at his trial, is so closely related to the informer as to make his identity and testimony highly material. The court continued and stated the circumstances of this case demonstrate that the informer's possible testimony was highly relevant. We see that word relevant again, and might have been helpful to the defense. We see helpful again. The Supreme Court noted that the trial court erred also in denying, prior to the trial, petitioner's motion for a bill of particulars, insofar as it requested the informer's identity and address, particularly because count 1 of the indictment charged an unlawful sale of heroin to the informer. The Supreme Court noted that this is a case where the government's informer was the sole participant, other than the accused, in the transaction charge. The informer was the only witness in a position to amplify or contradict the testimony of government witnesses. And five, the Supreme Court noted that Doe, who had taken a material part in bringing about Rivario's possession of the drugs, had been present with Roviaro at the occurrence of the alleged crime and might have been a material witness as to whether Roviaro knowingly transported the drugs as charged. Now, of course, this list is not exhaustive, but I wanted to give you some takeaways. And the general takeaway is that there is no fixed rule for when an informant's identity is privileged or not. The facts in each case will dictate the need for disclosure or the need to protect the informant's identity. The court considers relevance, whether disclosure is essential to a fair trial, the public interest versus the accused's right to defend self, significance and essentiality of disclosure. There are others, but if you find yourself in this situation, start with these and work your way through other considerations that would provide due process.